welcome to our webinar today. The webinar is sponsored by the Religious Freedom Institute Center for Religious Freedom Education, the First Liberty Institute, and RFI's Freedom of Religious Institution in Societies Project, a 3-year initiative funded by the John Templeton Foundation. We have an esteemed panel with us today. Let me move right into an introduction for each of them. Judge Ken Starr joined the Lanier Law Firm in 2018, building on a distinguished career in the law, academia, and public service. He works with the firm in an of-counsel position in a range of appellate matters, as well as other legal issues and causes of special interest. Judge Starr has argued 36 cases before the U.S. Supreme Court, including during his service as U.S. Solicitor General. He served as United States Circuit Court Judge for the District of Columbia Circuit, as Counselor and Chief of Staff to U.S. Attorney General William French Smith, and law clerk to both Chief Justice Warren Burger and to Fifth Circuit Judge David W. Dyer. He was appointed to serve as independent counsel for 5 investigations, including the Whitewater investigation from 1994 to 1999. In the world of academia, Judge Starr has served as president and chancellor of Baylor University and dean of the Pepperdine School of Law. For 25 years, he taught constitutional issues as an adjunct professor or visiting professor at 5 different law schools, and has served as a partner at 2 national law firms. Judge Starr is the author of more than 25 publications and has received numerous honors and awards. I would be remiss today if I did not mention Ken's forthcoming book, published by Encounter Press and available in February of 2021, entitled Religious Liberty in Crisis. Ken, we look forward to the publication of that book, and we welcome you to our panel today.
Thank you very much, David. So good to be with you.
Professor Richard Garnett joins us today as well. Professor Garnett is the founding director of Notre Dame Law School's program on church, state, and society, an interdisciplinary project that focuses on the role of religious institutions, communities, and authorities in the social order. He served on the Notre Dame Task Force on Catholic Education, as a fellow of the university's Institute for Educational Initiatives, and consults regularly with the Alliance for Catholic Education. Rick brings with him today a wealth of experience and mastery of legal analysis, well honed while clerking for the late Chief Justice of the United States, William H. Rehnquist, during the court's 1996 term, and also for the late Chief Judge of the United States Court of Appeals for the 8th Circuit. Rick also serves as an associated scholar with FORES, RFI's Freedom of Religious Institutions in Society Project. Rick, we are thankful to have you on board in that capacity. We appreciate all you do in the teaching and writing and speaking fields, and we look forward to your contribution today. Welcome to the panel.
Thanks for including me. It's great to be with you.
Finally, let me welcome Andrew Graham. Andrew, a good friend, serves as the Executive Director for Policy and Education and Senior Fellow at First Liberty Institute, where he leads the organization's academic activities. He's a regular speaker and teacher at conferences, universities, academic gatherings, and think tanks on law and religion. Before assuming that role at First Liberty, Andrew was a partner with Jackson Walker, LLP, a more than 130-year-old law firm with more than 400 lawyers across 7 Texas-based offices. In private practice, Andrew achieved an extensive record of success in high-stakes litigation in both trial and appellate courts. He has been named a Super Lawyers Rising Star numerous times. I do want to mention Andrew's recent brilliant article published August 18th in Public Discourse, Why Religious Pluralism and Religious literacy matter. Andrew, welcome to the panel today.
David, as always, it's great to be with you. Thanks for having me.
The end of summer 2020 brought with it the close of an unprecedented term for the U.S. Supreme Court. This was certainly true in relation to cases decided on the basis of First Amendment protections and other cases impacting fundamental principles of religious freedom. Over a 24-day period from June 15th to July 8th, 4 U.S. Supreme Court decisions were handed down that will likely impact the free exercise of religion in America for years to come. I don't recall a Supreme Court term in my lifetime in which there has been such a flurry of issues come before the High Court involving religious freedom, and certainly not a single summer with as many watershed cases decided. Legal experts have pointed out that for over the first 100 years following the founding of America, there were no cases decided by the U.S. Supreme Court concerning the Establishment Clause or free exercise clause of the First Amendment. Following Reynolds v. United States in 1879, which most consider the first landmark Supreme Court case concerning the free exercise clause, it wasn't until the 1940s that other landmark religious freedom cases were decided by the Supreme Court. As we look back into the 60s and the 70s, we start to see more challenges to religious freedom taken up by the High Court. In 63, of course, the landmark decision in Sherbert v. Berner. In 72, Wisconsin v. Yoder. And as you move into the 80s, as many as 8 landmark decisions involving such issues as the display of the Ten Commandments, prayer before the opening of a state legislature, the presence of a nativity scene in a public park at Christmas, and others were considered. Another 7 or so cases in the 90s, approximately 11 landmark decisions in the first decade of the new millennium. But never before, to my knowledge, have we seen such a flurry of cases and flurry of Supreme Court decisions implicating the free exercise of religion for individuals and institutions in a single term. Why now? Why now? As I leave that question hang in the air, and we'll return to it, I promise, let me turn very briefly to framing today's discussion. Let me lay out a basic roadmap for us to follow. As you might be thinking, time is our greatest enemy. 4 Supreme Court cases, what a challenge. Aware of that constraint, we will confine most, not all, of our comments related to Espinoza, Our Lady of Guadalupe School, and Little Sisters of the Poor to the first segment of the webinar. We will revisit the importance of exemptions in segment 2 and consider in segment 3, the final segment, how the cases together impact religious freedom for the future. While we'll discuss in some detail the legal doctrines in play and the reasoning of the court in Bostock, my chief goal is to explore how we got to this point and what are the implications for religious institutions and free exercise. While we look to the law to protect our civil rights and fundamental freedoms, I would like to stress from the outset that law alone cannot protect the most fundamental and inalienable rights granted to individuals and enshrined in the First Amendment. Indeed, this is something we must do in community together. Finally, just a word about our title: More Rights, Less Freedom. Recent Supreme Court cases in the future and the future of religious freedom. The title represents an attempt to capture a contrast to capture where we are, not only legally, but culturally, as we consider the place of religious freedom in America. As a nation and community, we must emphasize equality under the law for every person. But we must equally affirm that our fundamental freedoms are not expendable. And in fact, that may be the very tension, the very contrast, the very tension set up in these four cases under consideration today. In this regard, we need to understand the difference between fundamental, natural, inalienable rights and the rights that courts may create, either legitimately or illegitimately, and then other rights, legal rights, legitimately produced by legislatures, but still not rising to the level of inalienable. Andrew, I'd like to turn to you to address those distinctions. Help us with those definitions. Ken and Rick, we look to your expertise as well, but that seems to be fundamental for our conversation today to begin there. Andrew.
Sure. Well, thanks, David. And most fundamentally, certain rights, including religious freedom, are fundamental, universal, natural rights. That is, they are pre-political. They do not come from legislatures or courts. They stem from the very basis of human nature itself, from the way we are constituted as human beings, as people who exercise the faculties of reason, the faculty of conscience, and the faculty of free will. And while we're blessed in this country to have a First Amendment, we need to always be cognizant of the fact that our right to religious freedom is a pre-political right. And it's a pre-political right that's enshrined in the First Amendment, but it is antecedent to the First Amendment. And that should influence the way we think about religion in the public square.
Andrew, thank you for that. Rick, Ken, anything you'd like to add to that to lay the foundation for our conversation today?
If I might, just first to endorse exactly what Andrew said, that is, it's crucial to understand and appreciate the fact that religious liberty is a implication of human nature. It's not a concession from government. It's not a policy choice that governments make in order to manage their unruly citizens. It's more an acknowledgement that decent governments make of a fact about our nature, and really an implication of what the idea of human dignity requires. But just to add to that, it strikes me that it's important to remember that religious freedom is something that everybody has a stake in, whether he or she is religious or not. That is, a government that respects religious freedom is a government that is also more likely to respect other foundational and fundamental human freedoms, the freedoms of the press and privacy and association and due process and so on. But all of us should want our governments to be respectful of this pre-political right that all of us have to seek for the transcendent and to cling to the truth about the transcendent once we find it. There are freedom benefits for all of us, religious or not, to living under a constitutional order that respects religious freedom.
Well, that's a great foundation on which to build. Well, let me reach up in the air and pull that initial question back. Why now? How did we get here? Why are these cases being litigated in the first place? And particularly, why now, with such a flurry of concern and consideration? Let's take these cases one by one in this initial part of the webinar. And let's look at the Espinoza versus Montana Department of Revenue case. And Andrew, I'll turn back to you there. And what we want to do here is basically articulate the basic facts of the case, the issue, And we maybe consider any political or cultural factors that may have contributed to that case coming before the High Court at this time?
Sure. Thank you, David. So at this point in time, I'll address Chief Justice Roberts' majority opinion, and to a lesser extent, Justice Alito's concurrence. I'll save some other concurrences for later on in our discussion. But the issue there is essentially the Montana legislature had created a tuition assistance program, a program that provided a tax credit in exchange for a donation. And that tax credit was able to help students attend private schools of their choosing. However, the way the policy was interpreted, it had to be consistent with a provision in the Montana Constitution. It's called a no aid provision. We sometimes call them a Blaine Amendment. So what that did was prohibit financial assistance from going to denominational, sectarian, or religious schools. So what happens is the Montana Department of Revenue promulgates a rule saying that we're going to allow the program to go forward, but only with respect to money flowing to private, non-religious schools. As you can imagine, a lawsuit ensues, and what will ultimately be the case is Chief Justice Roberts, writing for the court, will hold, I think in a rather unremarkable fashion, that if a state legislature is going to provide tuition assistance programs for private schools, it need not do so, but if it does do so, it simply cannot discriminate between private religious schools and non-religious private schools. The issue that was squarely presented in that case was whether the free exercise clause of the federal Constitution trumped the Blaine Amendment, that no aid provision in the Montana Constitution. And ultimately, by a vote of 5-4, the U.S. Supreme Court here decided that the Blaine Amendment was violative and the free exercise clause did not allow for that type of restrictions on funds flowing through this tuition assistance program to private Christian schools or any other private religious school.
Andrew, you mentioned the no aid provision and also referred to as a Blaine Amendment. Is that a rather widespread amendment to state constitutions across the U.S.?
Well, yes, it is. And thank you for that question, because 38 states have these so-called Blaine Amendments. Let me just provide a little bit of background and history there, because it's an interesting portion of American history in the 19th century. Due to various famine conditions in Europe, there was an increase or an influx in Roman Catholics to the United States. And this was viewed by some as problematic for our polity. And Speaker of the House James Blaine in 1975 tried to pass a federal law that would have prohibited financial aid going to any sectarian school. Now, sectarian at the time was widely known as code word for Roman Catholic. And the public schools in the United States were largely thought of to have Protestant sensibilities, and the Roman Catholics wanted to establish their own schools to promote their own systems of faith and teachings of doctrine. Again, the purpose of this Blaine Amendment would have been to prohibit the flow of money to those Roman Catholic schools and also other private religious schools. But the motivation there was largely anti-Catholic animus in the 19th century. And that's an important part of the history. And Justice Alito's concurrence does a masterful job of going through this very long and detailed history. So, of course, the Blaine Amendment does not pass in the federal Congress, but because of that, it is adopted over the course of time by up to 38 different states. So, and this is the first time those Blaine Amendments have been challenged constitutionally. So it made Espinoza a rather remarkable case.
And many of those Blaine Amendments have been on the books in these 38 states for nearly 100 years. Is that correct?
Yeah, many of them were adopted at the very beginning of these statehood. So shortly after, from 1875 onward, 38 states would eventually adopt them. And again, this was the first time the Constitution had been challenged. So this was a major decision, and I think it's the right direction for religious freedom generally. I think it's good that the court acknowledged that part of our history with regard to religious freedom has not necessarily been very helpful or kind to our Roman Catholic friends.
Rick, I saw you nodding in agreement on most everything Andrew said. Would you like to add anything here, just the initial analysis on the Espinoza case?
Well, I think Andrew's summary is excellent. I was nodding because he's exactly right that Justice Alito did a real public service by just setting out some of the context and history for these so-called Blaine amendments. It's quite striking how few Americans actually understand the intensity of the not just religious hostility, but really political hostility to Catholicism that did a lot of work in the 19th century in the U.S. At the same time, it's worth noting that the Supreme Court did not rely on that history to conclude that the Montana provision was unconstitutional. That is, so far as the Supreme Court was concerned, it was the simple fact of discrimination against religious schools that made the Montana provision unconstitutional. The verdict didn't depend on the sort of ins and outs and ups and downs of the historical analysis. For me, this was, I have to confess, if it's okay to be a little personal, it was a wonderful experience because one of the very first cases I ever participated in as a young lawyer was an effort to bring down the Blaine amendments in the mid to late 90s. And of course, we were unsuccessful, but it's nice to see that come around after 2 decades.
Judge Starr, what about you? I'm imagining in the breadth of your experience, you've had some personal relation, perhaps, encountering the Blaine amendments as well.
Well, we all have, because they've been around for so bloody long. And it's long past time for them to go away. But the Supreme Court has seen fit to, I say, circumnavigate the fundamental issue of the evil history that the court has been willing to consider in other contexts, including even this term, including in an opinion authored by Justice Gorsuch, involving a totally unrelated issue, and that is whether a unanimous jury is required by our Constitution. Must it be unanimous? Most states say yes. So the overwhelming majority say yes. I think 48 literally say yes. But Louisiana and Oregon were holdouts. So I think the laws changed certainly in Oregon. But be that as it may, in condemning the requirement of unanimity in jurors, Justice Gorsuch, speaking for a supermajority of the court, said its history of racism condemns it. Well, Justice Alito took note of that and said in Espinoza, why don't we look at the history of the Blaine amendment?
Yeah.
Because it is so sordid, it is so indefensible, and so why don't we, if it's sauce for the goose, sauce for the gander? So the court was actually inconsistent. Justice Gorsuch was inconsistent in this very term. So consistency is a hoped for goal in law, including constitutional law, unless you're prepared to overrule a case. Hopefully we can talk about that as the proceeding unfolds. I also just want to say 2 things. With respect to your opening question, but I don't need to march on, these insights that Andrew so beautifully stated is not new. It has been articulated for centuries, especially by Christian writers, Christian authors, sometimes from other religious traditions as well. So it is deeply rooted in Western thought, literally for centuries. Secondly, it has tremendous, namely the philosophical, theological basis for religious freedom, going to the nature of man, created in the image of God from a Christian perspective, from a Jewish perspective. This has powerful, practical value as shown by social science. And mention was made of it, namely, countries that have religious freedom are more prosperous, have higher education, health incomes, moreover, final point, a great deal of work has been done in social science to see the effect of missionary work in the country. We sometimes say, oh, missionary work, why don't we just leave these good people alone? Guess what? The social science, this is not anecdotal, this is social science, show better outcomes of the three great secular criteria of human flourishing: education, income, health. Those criteria, those indicia of oneness go up in countries where Christian missionaries are allowed in. No surprise to those of us who've observed the mission field with great admiration. We think of the great example of Albert Schweitzer with his extraordinary genius in music, 2 PhDs, one in philosophy, one in theology, and he becomes a Christian missionary to sub-Saharan Africa. The upshot was that country, certainly that part of that country, was so much better. Education, income, welfare. Religious freedom is good.
Well, thank you for those strong and clear insights. And, as I reviewed these 4 cases, I think I could have just landed on Espinoza. We could spend the entire webinar there. Fascinating case. The concurring opinions, absolutely insightful. And we'll come back to that because I think they shed some light on other comments we'll want to make going forward. But let's keep our foot on the gas here. And let me turn back to Rick. Rick, you have the unenviable assignment here of actually covering 2 cases in a matter of minutes. But if you could help us with the Our Lady of Guadalupe School versus Morrissey-Berru, and then also Little Sisters of the Poor, Saints Peter and Paul Home versus Pennsylvania. Set the context for us, if you would. Identify the basic facts of the case, the issue, and the decision, and then we'll return to those, as I said, later in our discussion, particularly as they relate to exemptions that help us understand the context in which we find ourselves today dealing with religious freedom. So, Rick.
Sure. So the Our Lady of Guadalupe case, which was conjoined with another case called St. James, we can think of those as really being the other shoe dropping, if you want, from a Supreme Court case that was decided about 8 years ago called Hosanna-Tabor. And what had happened in Hosanna-Tabor was that a 9-0 court affirmed that the First Amendment, both in its free exercise clause and through its establishment clause, that the First Amendment does not permit the government to tell a religious institution who will or who will not be a minister. And by minister, they didn't mean simply a member of the clergy. So in the Hosanna-Tabor case, again, the issue had to do with the application of a non-discrimination law to a religious school's decision about a particular teacher. And drawing on centuries of history and on a sort of deeply rooted understanding of what church-state separation really means, Justice Roberts had emphasized that it's a foundational commitment of our First Amendment that religious institutions get to decide on their own teachings, their own liturgies, they get to determine matters of internal governance, and most importantly, the court appreciated that the right to choose your own teachings includes the right to choose your own teachers. Now, that wasn't a particularly controversial point 8 years ago, and it reaffirmed what many lower courts have been saying for 30 or 40 years. What happened in this term's cases, St. James and Guadalupe, was that the U.S. Court of Appeals for the Ninth Circuit had issued some decisions taking a very narrow approach to determining which kinds of employees are covered by this rule. The Ninth Circuit had taken the Supreme Court's very generous decision in Hosanna-Tabor and converted it into kind of a narrow mechanistic opinion where the only positions that were covered were ones that involved clerical titles or extensive religious training. And so in this case, by a vote of 7-2, with Justices Kagan and Justice Breyer joining the 5 more conservative members, the court really just reaffirmed what it had said 8 years ago and said, no, we mean it. The First Amendment protects the right of religious institutions to choose their own teachings. It's a very important ruling. It's a welcome ruling, hopefully a correction to other courts tempted to try to narrow the Supreme Court's decision. And in my view anyway, this is a vindication of what the the phrase separation of church and state was always supposed to mean. It was never supposed to mean no religion in the public square. It was supposed to mean that political and religious authorities are distinct, and that political authority ought not to interfere with the appropriate jurisdiction and domain of religious authority. So again, a welcome decision, correctly decided, and thankfully decided not by a narrow 5-4 partisan line. The other case you asked me to mention was just the Little Sisters of the Poor case, and this is kind of the latest iteration in this Dickensian saga that was launched with the Affordable Care Act a decade ago. Listeners are probably, or viewers are probably familiar with the Hobby Lobby litigation, but the idea here is just whether the mandate that was contained in the Affordable Care Act that employers had to provide cost-free contraception coverage to their employees, whether that mandate could be applied to religious institutions. Now, in the Hobby Lobby case several years ago, a religious employer had used the Religious Freedom Restoration Act to say that contraception coverage mandate constituted a burden on their religious freedom and was illegal under the Religious Freedom Restoration Act. What this past summer's decision involved with the Little Sisters of the Poor, it wasn't whether the free exercise clause or the Religious Freedom Restoration Act required an exemption for the Little Sisters who didn't want to provide this coverage. It was whether the government was even permitted to provide an exemption to the Little Sisters, because the government had done precisely that. That is, the current administration had decided to extend an exemption that was more generous than the one that had existed before, that said that religious employers with objections to providing this coverage didn't have to provide it. And yet this decision to provide the accommodation was challenged on various administrative law and procedural grounds. And so the upshot, it didn't have to do, again, with the interpretation of the First Amendment. It had to do more with administrative law, but the court said, no, this kind of accommodation is permissible. Now, some of the concurring justices went a little further and said, not only is this accommodation permissible, it would have been required under the Religious Freedom Restoration Act. But unfortunately, given the way the decision was reasoned, it gets sent back down for further proceedings. And of course, a future administration could easily undo the accommodation if it wanted to. So it looks like the Little Sisters, who've been embroiled in a lawsuit where the government's trying to make Catholic nuns provide contraception coverage to their employees, it looks like they'll probably continue to be in court for several years to come.
Mm-hmm. Well, on that note, I was going to mention, I think the litigation with the Little Sisters began in 2013. The Little Sisters have to be tired. And my next question to you is, you really just began to address it. Did the Little Sisters now get to rest? And it appears as though they may not. That may not be the case.
No, I think that's right. It's almost certainly the case that the accommodations that were extended to the Little Sisters and other religious employers by the current administration will continue to be challenged. And again, depending on what happens with a succeeding administration, the accommodations could go away. And then, of course, there'd be more litigation under the Religious Freedom Restoration Act. So this conflict, unfortunately, doesn't appear to have an end in the near term.
Yeah. You mentioned one other thing I want to tag back to, and that was the fact that in both of these cases, Justices Breyer and Justice Kagan both ended up voting with the majority. Yep. And it's a little odd. We don't see that often. I wondered if you just kind of further elaborate on why you think that's the case here, and why in both of these cases they aligned with the majority opinion.
Well, sure, and I'd expand it even further, to be honest. Justices Breyer and Kagan were obviously with the unanimous court in Hosanna-Tabor. They were with the majority in a case called Trinity Lutheran, which laid the groundwork for the Espinoza case that Andrew talked about. And as I mentioned, they were in the majority in the Guadalupe case. I think that's a very welcome thing. It ought not to be the case that an appreciation for a correct understanding of church-state relations and religious freedom, that should not be the domain of one of the two jurisprudential camps. Now, of course, there have been 5-4 rulings as well in recent years involving law and religion and church-state matters. But we've seen Justices Kagan and Breyer repeatedly take a more moderate position, one that, at least in my judgment, is sensitive to the important role that religion has played in American traditions and in American public life. Just one more example, again, it's not from this last term, but from the term before, there was a very important case involving a war memorial cross display in Maryland. And there was litigation to have this cross declared a violation of the Establishment Clause and perhaps moved or modified in some way. And there too, Justices Kagan and Breyer took a more, at least by my lights, reasonable and kind of history appreciative approach. So that's a welcome sign. Religious freedom ought not to be a partisan issue.
Well, thanks, Rick. Ken, welcome back. We understand these technical difficulties. I have feared all along that thunderstorms in North Texas might completely send me off the screen today. And so if I disappear, please talk amongst yourselves. But welcome back and very timely return. Ken, let's pass the baton to you. And in this kind of closing section of the first segment, help us identify the facts of the case, the key issue, the ruling in the Bostock decision. We're going to move there in the second segment of the conversation in more detail, but please set the stage for us if you would.
Yes. David, I hope you can hear me. I am having trouble hearing, and my wife tells me I need a hearing aid, but I think the issue is beyond that. Can you hear me? Thumbs up if you can.
Well, you're broken up, but we can hear you to some extent.
Okay. Well, I'm getting enormous static, and so I do apologize. I'll try to be succinct, but also not talk too fast. Bostock, the Title VII case, and I think the issue that you're going to address is, what about this case? Justice Gorsuch was the author of the case, and then the very powerful dissents by both Justice Alito and Justice Kavanaugh. Let me ask Justice Alito what dissent to describe.
Ken, let me just say you're breaking up a little bit more noticeably here. And I'm afraid that our audience may not be getting all of the content. I might suggest we had a brief conversation yesterday, and my communications expert, I'm not savvy enough to realize how this helps, but you might try moving to the location you were at yesterday. Our conversation was very clear, but I just wanted to let you know we're probably not getting all that we would like to get right now in terms of just hearing you.
Apologize. So you may want to pass the baton.
Well, let me pass the baton, if it's okay. Pass the baton back to Rick. And Ken, you may want to try reconnecting or perhaps your other location. So let's do that here, because we really want to get your analysis, Ken, particularly in this second segment that we're moving into, is where we'll value your analysis most. Rick, do you mind picking this up at this point and helping us through the kind of the initial laying the foundation on the Bostock case?
Sure. Although I'm painfully aware that when it comes to covering a case like this, I'm at best a junior varsity Ken Starr. But Bostock is the name we're giving to kind of a cluster of consolidated cases that have to do with the interpretation of a landmark anti-discrimination law, Title VII of the Civil Rights Act. And one of the things that Title VII of the Civil Rights Act of '64 does is it makes it unlawful for an employer to discriminate, quote, because of any individual's sex. So the case involves the interpretation of this statute. which prohibits, again, discrimination because of sex. Now, for years, in a variety of cases, and also, of course, just in the public discourse, there have been debates about whether Title VII should also apply to job discrimination on the basis of sexual orientation, and more recently to job discrimination on the basis of gender identity. And litigants over the years have argued that, well, the statutory text, when it says because of sex, that also means sexual orientation and gender discrimination. That the terms should be interpreted broadly to include discrimination on the basis of these other grounds. But for years, courts rejected this argument, not because of policy reasons, but because the statute simply doesn't say that. And of course, all kinds of state and local governments have specific prohibitions on discrimination on the basis of sexual orientation or gender identity. And there have been bills pending in Congress for years to add these new prohibitions to Title VII. Well, what happened in Bostock is that a 7-justice majority, in an opinion written by Justice Gorsuch, said that, well, actually, even if one confines oneself to the terms of the statute, to the text, it turns out that discrimination on the basis of sexual orientation and discrimination on the basis of gender identity necessarily involve discrimination on the basis of sex, and therefore are already prohibited. And what struck some people, I think, is strange about this opinion was that it was interesting that the 7-justice majority had, after decades and repeated instances of litigation and notwithstanding fights in Congress, had discovered this new meaning of the term because of sex. There were dissents, of course. I believe I said 7 justices before, but that was a mistake. It was 6. There were dissents, and for me, the one that was particularly compelling was the one from Justice Brett Kavanaugh, who is also a textualist when it comes to statutory interpretation, agrees entirely with Justice Gorsuch that when one's trying to figure out what a statute means, one should look at the statute's text and not at various policy considerations and so on. And he made the point that to be faithful to a text is to be faithful to the ordinary meaning of the terms that the statute uses, and not to kind of a strange, crabbed, literal meaning. And Justice Kavanaugh pointed out that, in effect, what Justice Gorsuch had done was to sort of read the statute as if the words, each individual word, were unconnected to the others. And Kavanaugh said, it's just not plausible that the phrase because of sex in this particular statute also prohibits discrimination on the basis of sexual orientation or gender identity. Now, on its face, this is not a religious freedom opinion, but as we're going to be discussing, there certainly would appear to be religious freedom implications for it, and a number of the justices addressed those implications in their opinions. So I hope that's a helpful way to set it up.
No, absolutely, Rick. And what I'd like to do is reserve the right to come back to several points that you made. And at this point, I want to go back and ask one question, basically in consideration of all the cases now that came before the High Court in the summer of 2020. The fact that these issues came before the court now, does that in some way represent a systemic or systematic failure of religious freedom? That is, the ideal itself and the institutions that support the ideal. So is there some type of systematic failure and a rejection of religious freedom as core to the common good that has been given a voice during the summer of 2020? So let me just open that up to all of you in consideration of all 4 of the cases.
Well, I've been talking plenty, so I'll defer to one of my colleagues to start us off.
I'm happy to jump in if my communication is better. Can you hear me? Okay, good. Thank you. And I do apologize. It seems to be entirely at our end here in the beautiful Sunshine State. So Yes, there is an enormous body of case law being generated because the pressures on religious liberty are legion. They are not only legion now, they are growing. This is a growth industry. And so thank goodness for scholarship like Rick Garnett. Thank goodness that we have First Liberty that Andrew is so importantly involved in. These are absolute sentinels. They are now justice warriors because, my dear friends, we are, in fact, we who love our constitutional order, our Bill of Rights, our first freedom, should all be quite worried of what is happening. Let me give you an example from a few terms ago, and that is the challenge to the Bladensburg, Maryland Memorial Cross built in the wake of World War I. It stood for decades. Suddenly, out of the clear blue, the American Humanist Association, perfectly lawful group expressing its views in our constitutional order, brings a lawsuit and strikes gold in Richmond, Virginia. And the Richmond, Virginia United States Court of Appeals, is a very distinguished court from the Fourth Circuit, says something's got to be done. So Bladensburg, Maryland, do something. One judge, I could name his name, but I won't, said you may have to saw off the arms of the cross. Friends, this would be unthinkable. I think as recently, certainly, let me just choose a decade, the 1990s, when President Clinton signed into law the Religious Freedom Restoration Act, which was passed virtually by a unanimous Congress to overturn a case that hopefully we'll talk about, called Employment Division versus Smith, to restore the idea of strict scrutiny. In other words, a government restriction on faith, on freedom, is going to have to pass the toughest test that has been formulated by the Supreme Court of the United States, called strict scrutiny. The government is going to have to come up with a compelling interest to justify its action. Justice Scalia, even Homer nodded, drew that into serious question with the decision in 1990 in Employment Division versus Smith, and the world rose up in righteous indignation and said, we got to restore religious freedom, the strict scrutiny standard. And again, President Clinton signed it into law in November of 1993, noting that there wasn't just a consensus, there was a virtual unanimity. I think that era has passed, and now there's great, for reasons we can get into, in terms of the culture, tremendous hostility to religion in all of its forms. So let us be thankful that we have, even with Justice Gorsuch, we were about to talk about his very strange decision in the Title VII case called Bostock. But he has been a vigorous defender of religious freedom. And I want to simply say, thank goodness, as Rick was saying a few minutes ago, that this has not broken down on partisan, ideological, as it were, lines, that there are 7 justices on the court who are strong friends of religious freedom. Not uniformly, but for the most part. And that's a huge blessing, and I think it should be a huge source of comfort to the American people.
Judge, those comments really help us really get right to the next point and move into the second segment of our webinar, where we really want to go in and focus on the Bostock decision. So moving from how did we get here to where are we? Where are we in terms of law and culture? And if you'd permit me just a moment, I want to track back, Rick, to a point you made that Justice Gorsuch, in the majority opinion, aligns his thought with the textualist approach. So we want to bring that into the conversation here. But let me read two comments from Justice Alito that help frame this part of the conversation. Justice Alito says the question in these cases is not whether discrimination because of sexual orientation or gender identity should be outlawed. The question is whether Congress did that in 1964. And then he continues and he said, if Congress did not intend that meaning in 1964, what does that say about the Bostock decision, political and cultural influences about the court, and implications for religious freedom and religious institutions going forward? Ken, I think you struck that nail on the head when you said there may be some cultural influences here going on. So I want to track off of those comments by Justice Alito. Help us to think through the mind of Congress, the plethora of litigation through the years that have increased in the last 2 to 3 decades that focus on these issues of civil rights, sexual orientation, and gender identity. Help us to understand, was in fact Justice Gorsuch following that path of textualism?
Absolutely not. It is the most tortured opinion I believe I have ever read with respect to statutory interpretation. I had no hair left, but I was pulling out any kind of hair that was available in a state of disbelief and the like. So Justice Alito has some very choice words. Arrogant and so forth. And it was a very, I think, just anti-textualist opinion because let's just set the stage, and perhaps you've already said this. The key is, what was the ordinary public meaning? And what does that mean? What does the ordinary American think when he reads the 1964 Act in 1964? Congress is legislating and President Johnson is signing. This is a very, very important statute. Now, the word sex ended up as a criterion, a forbidden ground for discrimination, was added, and there was not a whole lot of discussion. But a textualist approach says, we don't care what the legislative history is. We want to look at the law. What is the text? What Justice Gorsuch has ushered in, I think, is a very wooden literalism that still doesn't work when you look at the dictionary. So let's just pose what I think is the fundamental question. Is there a distinction in ordinary discourse now, but think back to 1964, between and among the word sex and the word sexual orientation and gender identity? And the answer is, of course there is. And even Justice Gorsuch, in his opinion, has to, and he uses 10 hypotheticals. I got really fatigued and a little bit annoyed in working through his hypotheticals. And I'm going to say it, I'm going to be very disrespectful. Some I thought were silly. And in any event, his hypotheticals were authoritatively answered by Justice Alito in the dissent. There is a distinction between sex and sexual orientation. So Justice Gorsuch has to say, well, inextricably related to, closely related to, so some sort of modifier, but that's not what Congress wrote. It wrote the word sex. And as defined then and now, sex means biology. That's what it meant in 1964. Now, you asked about what happened in the supervening or intervening years. As Americans became more aware of the pain of exclusion of individuals and considering the generosity of spirit, the expansion of categories of protected classes, these issues were discussed. They weren't discussed in 1964. As Justice Alito noted in his very powerful dissent, homosexuality, let's just stay with that, was in fact against the laws of the United States in various respects. The military, out you go. Individuals seeking entry into the United States, you're not admitted if you were a homosexual. Now, we don't applaud that, but the point is that was the understanding in 1964. And so it is that in the intervening decades, David, since 1964 and numerous interpretations of that term sex, 30 appellate judges over the decades rejected the idea that sex meant sexual orientation and gender identity. Should the law be changed by Congress? And that was Justice Kavanaugh's very powerful additional dissenting opinion, a separation of powers based decision, that it's really up, and we all understand this. I don't need to belabor the point. It's up to Congress, it's up to the president, it's up to the American people in a representative democracy to make these changes. And thus there were numerous bills under consideration over time. And I think one of the most powerful of many powerful points made by the dissenters is this process not only usurped the role of Congress and the president, but it cut off the conversation. Because now, as Justice Alito pointed out, over 100 federal statutes use the term sex. So we have to start now thinking about, okay, what does this mean in terms of housing? Justice Alito had a very thoughtful and poignant 2 paragraphs saying religious freedom. We've been talking about the autonomy of religious institutions in Our Lady of Guadalupe, but what about the ability of Our Lady of Guadalupe and St. James and Hosanna Tabor and other kinds of religiously affiliated schools to say, excuse me, the lifestyle coach, you're not teaching religion at all. The lifestyle that you're leading is not consistent with the tenets of our Christian or Orthodox Jewish faith and so on and so forth. We should have had a conversation as a country, and we were having a conversation as a country about that. So the perfidy of the opinion is that it cut off that conversation, usurped the role of the Congress of the United States, and essentially updated a statute that does not mean what the Supreme Court of the United States has said it means. It begs the question of why did Justice Gorsuch do it? To me, it represents simply, I'm sorry, I'm trying to move my camera here. It represents a radical approach to, quote, textualism, a literalistic textualism. And Justice Scalia warned us, there's a difference between literalism and textualism. Justice Kavanaugh, final point, because I think this makes the point, that a statute that says, so sorry, vehicles are banned in the park might be naturally interpreted to include baby carriages, but no one would take the word so literally as to deprive it of common sense or its ordinary public meaning. By the way, I hope we'll talk about why did Chief Justice Roberts, and maybe you've already talked about it, join the opinion and perhaps even assign the opinion, because this opinion will not stand in terms of its methodology. Its methodology is being praised by no serious scholar. Its result is being praised lavishly by the culture.
Judge, don't stop there. Tell us, why did Justice Roberts assign the case as he did?
Shame on you, David. Do I get extra credit? Well, again, it's a bit of amateur psychoanalysis, but I think the Chief Justice has shown that he is instrumentalist with his vote. He has not simply his conscience to respond to as an individual justice who took an oath to uphold and defend the Constitution of the United States, but he is the nation's Chief Justice. He's there to protect the court, and tossing one's vote in favor of a result with which one doesn't agree is very John Marshall-like. John Marshall, the great Chief Justice, in order to protect the court and its integrity, but at a very different stage of our history, needless to say,
was seeking unanimity. Justice Earl Warren sought it admirably, nobly in Brown versus Board of Education. He did not want a divided, fragmented court. That's one theory.
Well, two quick questions. This one back to you, Judge. Does the Bostock decision establish a new protected class?
In effect, it does, but not for constitutional purposes as I see it. It's the interpretation of one statute, but nonetheless it has the ramifications for a whole host of statutes. At one level, it's a narrow, that is to say, it is a narrow case focusing on one federal statute, not state statutes, right? And he even said, Justice Alito even said, we're going to leave some of these pesky, my characterization, questions, such as, say, housing, women's athletics, bathrooms. We're going to leave that for another day. Well, how very nice of you to do that. And that's one of the reasons that I think Justice Alito called him out as being essentially irresponsible. What he has unleashed is now a wild, furious dash to the courthouse, invoking many different statutes.
Andrew, one specific question tailing on Judge Starr's comments. He points to the observation by Justice Alito in the dissent when Justice Alito says, and I quote, "There is only one word for what the court has done today." This is his opening line, as you know, in the dissent. Legislation. My question is, was Justice Alito correct?
In a word, absolutely. It strikes me that, Justice Kavanaugh was completely right that this violates separation of powers, and that essentially Justice Gorsuch got ahead of himself, because there have been a lot of people, obviously we've been talking about the Equality Act and other issues, trying to put the words sexual orientation and gender identity into Title VII. They've all been unsuccessful. I sense an impatience with the culture to move in that direction. So Justice Gorsuch essentially made a policy declaration in the guise of a legal judgment.
You a follow-up question here related to Bostock. You served as a clerk under Chief Justice Rehnquist in the 96 term. Would this decision have been handed down by the High Court under the Rehnquist court?
Hard to know. I suspect that it would not have, and I suppose the reason for that is was kind of telegraphed by Andrew a moment ago, is that in the majority's opinion in Bostock, one does sense, I think, a court that's kind of impatient with Congress's failure to amend Title VII, and one senses that the court believes that public opinion had moved to a point where Title VII ought to cover sexual orientation discrimination and perhaps also gender identity discrimination. And rather than wait for an admittedly frustratingly dysfunctional Congress to get the job done, they seized on what I regard as a kind of sophomoric exercise in textual interpretation to reach the result that they probably correctly guessed most people would approve of. I don't think that was true in 1996. We didn't yet have on the books a lot of the decisions that would be handed down on LGBT rights, on same-sex marriage, and so on. So in a sense, the cultural milieu, the atmosphere would have been different, such that even justices who might be sympathetic as a policy matter would have thought that the statutory interpretation was simply too adventurous.
So you mentioned that cultural milieu even around the time of 96. And I think based on your comments, Judge, then that you would agree this decision probably would not have been reached in the 80s, certainly not in the 70s. But this is where we are today, and that there are political and cultural influences that, in fact, do contribute to the decision. Would you agree with that, Judge Starr?
I would. We want judges and especially justices to be animated by what once upon a time been called neutral principles. The justice is supposed to be blind and to be following the great path of the law and the law's tradition, and that means words count. The words constitute the law. And while I will say, if you go back to the 70s and 80s, there was a certain looseness in the way the Supreme Court and lower courts interpreted federal statutes. I'll use an example. In one FCC case, Justice Byron White, certainly moderate justice, said, we're simply going to accept the interpretation of administrative agency of a particular statute unless there are compelling reasons to believe that it got it wrong. Another nostrum of the day was, we are going to interpret this statute consistent with its liberal and generous purposes. That kind of language came to a crashing halt, and I mean a crashing halt, beginning with Justice Scalia's service in the 1980s, when he would just call this kind of methodology into question, including his really rigorous separation of powers informed view that you shouldn't be looking to legislative history and so forth. Now, not all justices, even Justice Alito, will look at legislative history and so forth. And why is that? Because this pure and undefiled perception and conclusion that the law is that which Congress, by bicameralism, passed and then presented to the president. Right? The president doesn't have the benefit. The president's advisors doesn't have the benefit of all this, quote, legislative history and so forth. And legislative history used to be condemned, including in the mother country. We're not going to be looking at parliamentary debates. What's the law? They didn't pass the legislative history, et cetera, et cetera. And the final thing I want to say in terms of the change in interpretive methodology and judicial culture was, I think, captured by Justice Elena Kagan in her lecture, the Antonin Scalia lecture at Harvard in 2015, when she said, we are all textualists now. In other words, no more loosey-goosey approach, but what Justice Gorsuch ushered in is this very disruptive and I believe quite arrogant. We now look at the law, and we now see that 30 appellate judges over decades were wrong, all of them, and that the EEOC was wrong for 48 years or however many years, literally decades. They were all wrong, because all you had to do is read the statute and you see that sexual orientation and gender identity is covered. However much one may yearn for that and a more enlightened approach to individual rights, it is quite disruptive of our separation of powers system, especially, again, for the reasons Justice Kavanaugh put it. And it's ironic that those who were advancing this position were, even in oral argument, admitting its weaknesses. Pamela Karlan, a brilliant common law professor at Stanford who argued the case, had to go along with an Alito hypothetical that showed the linguistic difference, the plain ordinary difference between the term sex and then the term sexual orientation and the like. So I commend to our participants, if you say, I've had lots of conversations about this informally, go back to the text, go back and just read. It's long, but read the Gorsuch opinion, give him his due, but then read the two dissents. And I think fair-minded people will say, gosh, in terms of, if you agree that the role of the court is to interpret the law rather than update it, then I have to think that Justice Alito was absolutely right. This is a pirate ship. I love that metaphor that he used in the opening paragraphs. This is a pirate ship sailing under the flag of textualism, but it is not a textualist vessel at all.
Thank you. Thank you, Ken. For the sake of time, we're going to move on to our final segment. We've asked two questions. How did we get here over many, many years from 1964 to the present, really all the way back to the founding of the country in that first landmark religious freedom case? How in the world did we get here with this flurry of activity? And we ask, where are we? What does this mean in light of these three cases? But now finally, where are we going? What are the implications for religious freedom for the future? Does the Bostock decision open a floodgate of legal, moral, and cultural consequences that will sweep beyond Title VII to other federal or state laws that prohibit sex discrimination? Let me just point out, I think one thing we've already said, even Judge, as you were referring to Justice Gorsuch's own words, he seemed to acknowledge a forthcoming tsunami of legal concerns when he states, well, none of these cases are before us, but he anticipates they will be. So I want to think about these implications, and certainly, Rick, in light of the two cases that you've reviewed for today, and Andrew, the Espinoza case, some of the insight there from concurring opinions may weigh in on this, but what are the legal implications going forward? What are the moral and cultural implications? So let's start first for a few moments. What will be Bostock's progeny legally? Challenges to RFRA, an urgency to enact H.R. 5, the Equality Act, that within 1 week was brought to the floor in the Senate, not for a vote, but within 1 week. Where will free exercise continue to stand in relationship to individuals and institutions? Healthcare conscious protections, all of these things have legal implications. So let's start there for a few moments, very succinctly looking at the legal implications. And then I want to finish talking about the moral and cultural implications. Rick, why don't you lead us off?
Sure. Let me just, I want to hear from my colleagues, but you've mentioned the Equality Act. Another proposal that's been pending in Congress and proposed various times is sometimes called the Do No Harm Act. And what this would do would be to amend the Federal Religious Freedom Restoration Act to provide explicitly that religious freedom claims may not be brought in cases involving the application of anti-discrimination law, or in any case where an accommodation would cause some quote unquote harm to a third party. And that would be a fairly dramatic development. That would mean that religious freedom protection simply couldn't be invoked in cases where the burden in question was the application of a non-discrimination law to religiously motivated conduct or to a religiously affiliated institution. I'm speaking, as you know, in my capacity as a participant in the Freedom of Religious Institutions and Society project. And for those of us who care about the contributions that distinctively religious institutions make to civil society, this would be quite a thing. And related to that, I think we can expect to see, again, one always wonders how elections turn out, but I think it's reasonable to think that there will be calls in the wake of the Bostock case to say that all recipients of federal grants, federal contracts, federal funding, federal accreditation, federal licensing, that all such beneficiaries, in quotes, should be required to agree to comply with the understanding of non-discrimination that Bostock reflects. As you might imagine, most religious institutions have no problem signing on to a rule that says if they get a grant to cooperate with the federal government, they're not going to discriminate on the basis of race, say. But for a number of religious institutions, these questions of gender identity and sexual orientation might present different matters. And so we could see an effort to really cut off sort of traditional, distinctively religious institutions from participation in things like foster care placements, adoption, human trafficking fighting, refugee resettlement, and then think about the impact on universities. So those are just two things that I think we should see coming down the road towards us in the wake of this most recent year's decisions.
Rick, you mentioned specifically universities, so I wanted just to probe there just a moment. I mean, faith-based private schools, K through 12, faith-based colleges and universities across the country. What potential impact specifically might you see on those institutions?
Yeah, it's in a way an irony that the same year that we get a decision like Espinoza, which at least in principle, if it were faithfully applied, would be an engine for really increasing the ability of religious K through 12 schools to participate in funding programs, school voucher programs, and the like. The flip side of that is that I think we can expect to see more and more forms of government aid coming with strings attached. And those strings might include things like, for example, a religious institution, a university, say, that receives federal grants or contracts for research can't have dormitories that are segregated on the basis of biological sex. That would be a change to the practices of many kind of small Christian colleges, or perhaps some not so small Christian colleges. Think of the Guadalupe case, which I discussed earlier, involving the right of religious schools to select their own teachers. I think we can expect to see an effort to say, look, any K through 12 religious school that does not abide by a strict obligation to not discriminate on the basis of gender identity in hiring their teachers becomes ineligible for public funds. Well, that would have a dramatic, indeed crippling effect on parochial schools in this country. So it's important for people to remember that government power can be exercised in hard forms and soft forms. We're familiar with hard power, right? Hard power is when the government censors speech or puts people in jail or prohibits conduct or what have you. Soft power is when the government attaches conditions to things that you want or to things that you need. And I think we're going to see a lot more of that.
Yeah. Well, a final question for you, Andrew, and for you, Ken. Taken together, what might we expect the effect of these cases overall to be in the next 5 years? So looking down the road, considering the balance of what was decided in Espinoza, the Little Sisters of the Poor, Our Lady of Guadalupe, versus the Bostock case, where do you see us in 5 years in terms of religious freedom as it relates to the free exercise of religious freedom for individuals and institutions?
I think there's going to be a lot of litigation for a long time. And we're going to have to litigate the scope of RFRA's protections. Justice Gorsuch refers to it as a super statute in Bostock. We're going to have to see whether that is indeed the case. We had a lot of conversation today already about the ministerial exception from Our Lady of Guadalupe. I think we're going to continue to see litigation on that particular issue. And then one thing we haven't mentioned yet are the scope of the religious employer exemptions in Title VII. That's something else we're going to be litigating. And I think those issues are going to be on the table for a long time. And I don't know if a resolution to any of them will come particularly quickly. Now, I do want to make one suggestion, and that is I would encourage people to read the Thomas concurrence with which Justice Gorsuch joined in Espinoza, along with Justice Gorsuch's individual concurrence in Espinoza. And I would like to suggest if we read those as essentially a companion piece to the Gorsuch majority opinion, I think it presents some hope for those of us who are interested in the court preserving religious freedom judicially. And one of the reasons I say that is for the first time that I know of, Justice Gorsuch has joined on to the opinion with Justice Thomas, in which he writes regarding the free exercise clause. And I say this is Thomas writing. The free exercise clause, although enshrined explicitly in the Constitution, rests on the lowest rung of the court's ladder of rights, and precariously so at that. I look forward to the day when the court takes up this task in earnest. And again, Justice Gorsuch is joining Justice Thomas in that opinion. And then going a little further, I would say when you read Gorsuch's own concurrence, there are really some quite striking statements in there. So I think, remember, Bostock is decided on June 15th, and then Espinoza 15 days later on June 30th. And I think they have to be read together. I do think that Justice Gorsuch is signaling in the wake of Bostock that he is very serious about protecting religious freedom. And so what I would like to say there is just read one or two more quotes from Gorsuch's own concurrence, because I think they'll bring us back to where we started at the very beginning of our discussion, and they should provide at least a glimmer of hope that Gorsuch is going to do what he can on the court to preserve the free exercise of religion. And this is Gorsuch writing. What point is it to tell a person that he is free to be a Muslim, but he must be made subject to discrimination for doing what his religion commands? Attending Friday prayers, living his daily life in harmony with the teaching of his faith, and importantly for Christian schools or Muslim schools, educating his children in its ways. The right to be religious without the right to do religious things would hardly amount to a right at all. So I don't have a crystal ball, of course, but I do think he is here expanding on and trying to address some of the issues that are raised clearly in the Bostock opinion, and is trying to signal to us how he might vote on issues that come before the court, at least giving a robust commitment to religious freedom. So I know that's a long answer, but I think these things are important to highlight because I think it completes the picture, and looking purely at the Bostock majority may not give us a clear indication of where Justice Gorsuch might be with regard to religious freedom issues.
Great points, Andrew. I certainly concur. The Gorsuch concurring opinion in the Espinoza case is very insightful and brings clarity, I think, to his thinking on religious freedom. Judge Starr, a final word for you. Where would we be in 5 years?
We will still have a very fine Supreme Court dedicated to principles of religious liberty. Not always agreeing on rationale, but this was a grand turn on the pure religious liberty front. The 3 cases that we have discussed today are enormous victories, and we should be thankful and we should celebrate those victories. We've said enough about Bostock. So what will happen? I think that these principles, that these cases, these victories are rooted in deep principles. They're not ad hoc. Let's just take Our Lady of Guadalupe. Deeply rooted in the principle of autonomy of religious institutions. My friends, that is vitally, compellingly important. Doesn't mean that all football coaches and so forth will enjoy the ministerial exception and so forth, but it's a really wonderful, and we saw from the dissenting opinion, I think a wonderful extension and expansion of the original insights in Hosanna Tabor. Caesar, hands off. Get your hands off this institution. And let us not forget that in Hosanna Tabor, I'm going to go ahead and say it, the Obama administration, EEOC, took the position in that litigation, including in the Supreme Court of the United States, that a deeply religious school had exactly the same bundle of rights that the Boy Scouts and the Chamber of Commerce and the Rotary Club have. A view that was dismissed, not by 5, not by 6, but by 9 members of the Supreme Court, including Justice Elena Kagan, who had served as Solicitor General in the Obama administration. But there will be, perhaps, a very hostile to religious administration EEOC soon to come, perhaps a hostile to religious liberty Solicitor General's office and Justice Department soon to come. But the courts, God bless them, just continue, I think, time after time to get it right. Now, the next 5 years, we don't have to wait. Wait simply until next term. Let's join up again to discuss Philton versus the city of Philadelphia, which is a very important issue in terms of the hostile culture meeting the wonderful services provided by Catholic Social Services in the city of Philadelphia, beautifully, charitably, uninterruptedly for over 100 years. But they will not, consistent with Catholic teaching, place a foster child in a same-sex marriage home. And for that reason, the city of Philadelphia says, we don't want your services anymore. The culture has turned against religious liberty, as illustrated by the fact that the city of Philadelphia's position is supported by the American Bar Association.
Judge, thank you for ending on that very strong point. Let me thank each of our panelists today. Thank you so much for your friendship to the Religious Freedom Institute, to First Liberty Institute, and to Religious Freedom. Let me end with this closing remark with which I began. As a nation and community, we must emphasize equality under the law for all citizens. But we must equally affirm that our fundamental freedoms are not expendable. Law alone cannot protect the most fundamental and inalienable rights granted to individuals and enshrined in the First Amendment. This is something we must agree to do in community together. So on that note, thank everyone for attending today. Again, thanks to all of our panelists. We really appreciate your contribution, your insight today. Look forward to seeing you soon. Thank you.
Thanks, David.
Thank you.